Hi, I'm Laura Daly, attorney at Swartz Swartz. Today I want to talk to you about the differences between pre-litigation versus litigation. Basically, what it means is before you file a lawsuit versus after you file a lawsuit. But there are some differences that I want to make sure that you're aware of. In Massachusetts, for example, in a motor vehicle accident, you have 3 years to file suit, or you lose your right to pursue a claim. In some cases, it might be beneficial to begin your case as pre-litigation if you're well within the statute of limitations. Settling a case expeditiously for maximum value could be a great outcome, but sometimes, as a case develops, we find that the defendant is not being fair or reasonable in any effort to resolve your case, and in those cases, we find it necessary to file suit. In litigation, there's a different type of dynamic because you have the involvement of the court system, and there are deadlines that are prescribed by the court. You'll also have more involvement in the case when it's in litigation. For example, in almost every circumstance, your deposition will be taken. However, there's nothing to fear about being involved in litigation, and there's nothing to be nervous about, especially if you have experienced trial attorneys such as Swartz Swartz. At Swartz Swartz, we handle cases from start to resolution, whether it be pre-litigation settlement or jury trial. If you or someone you know has been injured at no fault of their own, please contact us at Swartz Swartz.